to prevent future settlements in relation to the same harasser.
I think there should be an obligation on the employer to keep that data. And that should be obviously taken into account when you're looking at a second, third, fourth offence. But you also have to look generally at the HR function in all of this, which isn't always very good.
You don't need to
put
tell
it mildly.
Yes, I mean, turning that round slightly, if you're looking at harassment by other than the controlling entity behind a body, an employer will have a defence to the actions of an employee harassing another employee if they can show that reasonable steps were taken to prevent harassment within the workplace. Now, trying to run that defence, if, for example, the employee in question was a serial harasser, would be, frankly, impossible. There may be more, though, to look at in terms of, that's a sort of slightly negative approach, saying you've got a defence if you've taken certain steps. There could be more with regard to positive duties within the workplace to look at the type of conduct to ensure that practices and procedures are in place as a positive rather than just as a sort of fallback position.
That's the HRC proposal. I'm bound to say that current level of protection, which you'd have thought would be attractive to employers, to take all reasonable steps to prevent harassment taking place, or indeed any other forms of discrimination, would encourage employers to put in place those steps. I've got to tell you, in the many years I've been fighting discrimination cases, I've very rarely seen that defence advanced, because presumably the employers, when they look at it, haven't actually taken sufficient steps to prevent that kind of discrimination. I'd be curious if your experience is different, Max. But
I've run that defence on one occasion.
Yes, I've run it once myself.
But that's the defence to avoid vicarious liability.
Yes.
We're talking about a positive duty that gives rise to a civil remedy, that you take reasonable steps to prevent it, not dissimilar to reasonable adjustments in disability discrimination cases. And that should give rise to a separate remedy under the Equality Act. I agree with that recommendation.
Okay, in the President Club's case, hostesses were allegedly asked to sign the non-disclosure agreements, preventing them from disclosing events that had not yet occurred. So the EHRC has recommended that the government should legislate to nullify any contractual clause preventing disclosure of future acts of discrimination, harassment or victimisation. Do you support this recommendation?
I'm not. It's clearly right that people shouldn't be prevented from doing so by signing contracts in advance, but I'm not sure they're effective already. I think actually the more interesting thing to do would be to make it a criminal offence to ask people to sign these agreements which have which are not valid. And for example, I think it would be good to make it a criminal offence to say in a non-disclosure agreement not to include the words, if you're going to have confidentiality clause, say this doesn't stop you referring the matter to the police or the relevant regulatory authority. And because if you don't include it, unless someone's got good legal advice, I'm afraid in the settlement agreement you'll always get some legal advice, but whether it's good legal advice or not doesn't necessarily follow. The employee's natural view is to read the wording on the paper and says, well, that says I can't tell anyone.
I think if we clarify the law on perverting the course of justice, to make it clear that it would include that kind of provision, that it would be perverting the course of justice to do it, I don't think we'd need a new part of criminal legislation. We just need clarity on that.
Yeah, certainly as far as civil claims. And so my view, anyway, is that the Equality Act already deals with that particular problem. You can't contract out of your rights before you've got them, whether that's the right to unfair dismissal or the right not to be discriminated. Just think about it from a common sense point of view. Given a document to say, well, you're going to go into an event where you may be harassed sexually, but by the way, sign this to allow yourself to be harassed. I mean, quite extraordinary. One of the distressing things about the President's Club case is the fact that those agreements were shoved under people's noses, as I understand it. They were asked to sign it, and then the document was taken away. The other angle to that, of course, is that one of the problems with that type of scenario is who's doing the harassing. As you'll probably be aware, the Section 40 of the Equality Act was repealed, which did cover, perhaps imperfectly, third-party harassment. But whilst there are some arguments to say that the law, as we've got it, could also cover that situation, I think Section 40 sent a nice, clear message to employers to kind of engage their brains before they put their employees in situations of
Although I
risk.
gently point out that that was in place and there were still problems with third-party harassment. So it may have helped, but it wasn't that effective, perhaps.
But we can't just rely on the Equality Act because not everyone falls within the definition of worker, employer or applicant for work. So,
Sorry, we're desperately running out of time. Gavin, do you...
Yeah, just very briefly, because we are coming up to the end here. Can I just check a couple of bits? So, Suzanne, I think you made a strong case for basically boxing out kind of rights that can't be abridged by the agreement. And did I understand that implicit in that is actually a level playing field for different lawyers who are drawing up these contracts so that everyone knows what's expected of them?
It's to cover off the 1 year, 2 year PQE. I understand experience is not always linear, but it's to cover off the lawyer who doesn't actually know that it is void, a clause that prevents you. And it's so that the claimant understands exactly what they're signing up to. There are other problems, though, where there are clawback provisions. So you are allowed to go to the police, but we'll take the 200,000 back off you if you do. That's more problematic, and that probably needs further consideration, those sorts of provisions.
So just on that, let me just run through a few things, because essentially that's asking for whatever you get there to more regulation that specifies what's acceptable, what's not. Do you think it's ever acceptable for a party to an NDA not to receive a copy of the agreement?
It's totally wrong.
Okay.
It can never be right.
Because presumably, how could you check to see if you're compliant?
In all my 25 years of practice.
What about the lifelong commitments within an NDA? Can you think of circumstances where that's important?
Yeah, you can understand how that might be justifiable. For example, if someone had made a false accusation of rape and someone wanted that silenced. I did a case once where a junior employee accused a senior employee of sexual harassment, and then when you looked at the videotape, which they didn't realise was occurring, it was completely the reverse way round. Now that senior employee was entitled to protection indefinitely, I would suggest. I mean, I just don't think these things are capable of simple solutions, I'm afraid.
Do you think there are any other circumstances in which there should be limitations on NDAs being used that I haven't just mentioned there?
Well, it's a related point, but one of my concerns is COT3 agreements, which can include NDAs, which go through ACAS, don't require a lawyer to sign them off on behalf of claimants. And I think that really seriously does need to be looked at.
Can you think of any particular way in which that gap might be closed between those two different types of agreements?
It's simply to say you can draw up the COT3, but it requires a lawyer to sign it off. Why aren't employers providing more money as part of these settlement agreements? If they want them signed off by the former employee, they can pay for it, and not just £250. Maybe there should be a minimum amount so that the person can take legal advice.
Okay. Can I just ask a couple of very final questions, and then we'll need to close. To Gareth, what is the Employment Lawyers Association doing to raise awareness and improve practices by lawyers on the limitations of NDAs, and particularly in light of the SRA's warning notice?
Well, the warning notice was pretty recent, to be fair, and I do agree that it seemed to me the focus of the warning notice was on how solicitors manage their own practices rather than how they deal with these kind of issues, although I agree there's something of a sideshow in that regard. The answer is at the moment, well, I will raise it at the next management committee meeting, and we will try and deal with it through that method. But frankly, we're going to be, people can write articles in the ELA briefing, which is like our newspaper, and people can give speeches about it. That's the extent of it until the law changes.
But can the law regulate ethical standards?
So the Employment Lawyers Association does not regulate its membership other than by virtue of the fact that everyone has to be a lawyer within it. So if someone has breached solicitors' regulatory standards, then they may be struck off or disciplined by the SRA, and if they are, then they'll no longer be able to be a member of the ELA. But we coalesce with that, yeah.
Can I just say,
Yeah.
I mean, you might say, being an MP, I'm leading with my chin here, but what does it say about the legal profession, that you're all very clear on the Solicitors Regulation Authority's principle about acting in the best interest of each client, but you all seem so vague and have no idea what on earth is meant by upholding the rule of law and the proper administration of justice, acting with integrity, and behaving in a way that maintains the trust the public places in you and in the provision of legal services. I mean, isn't that a reflection of the legal profession, that one of those is very clear to you and the other three you seem to have no idea what any of them mean?
I disagree. I've been very clear about my views.
What I was trying to say is that there are sometimes boundary disputes. You have to be sure, before you're not acting in the best interest of your client, you have to be equally sure that you are obliged, that you cannot do that. For example, sometimes you're obliged to disclose a document, okay, which might be harmful to the client. If you take the view that you have to disclose that document, then you're clearly not acting in your client's best interest, but you have to do it. And I have been in that situation many times, and I can assure you that I and most of the solicitors I've ever known have exercised the highest level of integrity. Not everyone, but mostly, okay? But if I was wrong about that, and actually I didn't have to disclose that document, I've also breached a regulatory obligation. So these are quite fine judgments. And in fairness to Mark Mansell, I'll say a couple of things. Back in the 1990s, I could be corrected if I'm wrong, whilst I accept the general principles. It used to be that the SRA rules, or the equivalent, the Law Society rules, were very prescriptive. So what you used to have was a very long book with lots of very detailed rules about how you were supposed to behave in lots of different situations. And over time, they've slimmed it all down to being about high-level principle. There were always some high-level principles. I cannot remember what they were back in the 90s at the time. But you know, I hope that answers your question to some degree. But it's not as straightforward as it sounds. I know what you want me to say, which is we're keener to protect our clients' interests than we are to uphold integrity in the law. That's not my experience of lawyers generally, and certainly not my own personal practice.
Just a supplementary on that, though. I mean, Suzanne, you did say people's, I didn't write it down, but people's approach to ethical standards are different. So you did acknowledge that that there might be a different approach here. I mean, I would hope that people's approaches wouldn't be that different. Or what do you think drives those differences?
I've been doing this job for nearly 30 years. What I can see is people's approach to me has changed in that time. So the attempts to coerce me into an unfair bargain has radically reduced in that time. But my memories certainly, and I see it in junior lawyers now, if you're up against the big guns, they will do what they can to exert influence over you. Now, whether it's undue influence is a moot point. But I don't think we can work on the basis that every lawyer is perfect and every lawyer has the right experience and every lawyer will do the right thing.
I mean, I think lawyers will often see their role as to make the employee feel corporate power and feel the weight and the might of people against them. But one hopes that with legal representation that they can resist that. I've actually had Mark Mansell on the other side in negotiation. I can tell you that he's certainly no worse than others. I think probably better actually in that regard. So he may be unlucky. I don't know.
Brilliant. Any other questions? Thank you all so much for being here today. Really grateful to you for your time and for the evidence that's being given to the committee in writing as well. And if there is anything else you wanted to give to the committee based on your extensive expertise, we'd be very grateful for it. Thank you very much. Thank you. We're now going to have a very short private session, so if I could ask our witnesses and members of the gallery to leave swiftly, I'd be most grateful, only I'm already overrunning